Do you confirm that you're still under oath? If you do, say I do.
I do.
Thank you, Doctor. Can we proceed then to page 7 of the bundle? Your statement. I think you are dealing there with a new topic titled, Was there corruption in the SDPs? And you start by referring to a subtopic, Roman figure 1, findings from a number of international investigations. Can you take us through that?
Yes, Chair, now I try and build my second argument. It's the argument to try and shed light on the big question. The big question was, given what we know, given what's in the public domain, do we have reason to believe there was corruption in the STPs? I will refer to a number of allegations, cases, findings, investigations, but hope to do so in a way that they coalesce into a bigger, almost self-reinforcing picture where themes develop, where we start to see patterns, we start to see personalities, we start to see certain common types of behavior, and altogether that we come to acknowledge the probability that it can't all just be nonsense. I'll do it in two parts. The first part concerns investigations that relate to the South African arms deal that were undertaken in other countries, namely countries of certain of the suppliers of our arms deal. I will just refer to the main ones. I've established that there have been other smaller international investigations, some in-house, the findings of which are there, not too well known. But after having dealt with that, the international findings, I will then turn to some other allegations, another set of allegations, which again, most of which we would have heard about. I'm quite selective about the allegations I refer to because I don't want to waste your time with wild allegations, unsubstantiated allegations. And as I said in my opening remarks, here too I will only refer to allegations which I believe we can say have some basis. And it's those two parts together, the international findings and these allegations, that when we put them together, I hope we can conclude that it's reasonable to believe that corruption took place in the South African arms packages, perhaps on quite a wide scale. I begin with the international investigations. And here I'm quoting from sources which are in the public domain. So I think the investigations which cover BAE, the SARB deals, and Ferristal, and one of the common themes is that they all seem to refer to dubious payments which were made by the suppliers. Payments that were made to South African politicians, public officials, arms deal-related businessmen and other middlemen. And I begin with a specific German investigation into Ferristal. May I just continue?
As I indicated previously, that the report that is mentioned in paragraph 16, subject to the commissioners, is subject to attorney-client privilege. So insofar as you refer to it, just be conscious of that. But you may proceed to deal with it, and where you stray away, I think the commissioners will be able to guide us.
Thank you for that advice. Yes, I'm referring to this particular case where findings are in the public domain from what was supposedly a leaked confidential document. So I appreciate the sensitivities around that. But nonetheless, those allegations are in the public domain. They do have substance, and I would want this opportunity to at least place them on record and to ask the Commission that they do reflect on them. So there was the audit by a US-based law firm into the Ferrostyle deal, which amongst other things showed that Ferrostyle had close links with Chippy Shake. We'll find in other evidence I provide later on that link between Chippy Shake and Ferrostyle crops up all the time, as does Chippy Shake's links with other suppliers. And that's, I'd like to register as one of the themes which I'll build up to and then give some direct focus on towards the end of my presentation. And it regards the building of submarines, where the allegations are of amount of $40 million being paid to agents in South Africa, and where the leaked report is reported to say the chief attraction, of these payments was their influence on politicians. And I refer you back to my earlier illustration of how bribes work and who they target and for what reason. Just to give some detail to this particular investigation, I refer to an annexure GGW 8.
It's on page 66 of the bundle.
Advocate Mpara, just before we pass this point, I see this is an article by Mail and Guardian. I'm not quite sure what is the evidential value of that article from Mail and Guardian. I'm really not sure, unless if it's all the journalist who wrote this report comes in and testify. Otherwise, if it's all just an article from Mail and Guardian, I'm not quite certain about the evidential value thereof.
Thank you, Chair. As you've heard the chairperson, what value do you want to attach to this article which you have referred to in the Mail and Guardian?
Well, in that the contents of the article have not been contested. The fact that there was an investigation, even if the findings were leaked, has not been contested. So I believe it amounts to allegations that we should take cognizance of, and that, as I requested, Chairperson, I would like to have put on the record. They also are allegations which, as my evidence unfolds, you will see give credence to other allegations and offer a certain consistency of particular events which developed around the Ferrostyle submarine deal. So hopefully I'm replying to your question and answering what I believe the relevance of this Mail and Guardian article is.
Chairperson, we object to this particular account in the Mail and Guardian. It has lots and lots of allegations which do not add to the issues or elucidate the issues that this commission has to decide. I'm referring, for instance, to the allegation on page 67 in the Sunday Times, reported that Ferrostaal allegedly gave former President Thabo Mbeki 30 million rand in bribes, and that after sharing this with Jacob Zuma before he became president, Mbeki gave some of the money to the African National Congress as a donation. Then Mbeki has denied the claims. What is the value of this, apart from just throwing mud?
Mr. Chairman, if I can come in here, we are actually dealing with an issue that we've dealt with in quite some detail with Mr. Manier's evidence, and you've made a ruling there. It appears on page 7943 of the record, where I raised the same issue that you have now raised and that Mr. Morane dealt with reference to my client, Mr. Shlongwane and Shlongwane Consulting. We studied the submissions by this witness, and actually there's not a single aspect raised in the submission that's based on any admissible evidence. The witness clearly doesn't have any knowledge of facts, and he relies on mostly Mail and Guardian press statements and articles, as well as a email emanating from Mr. Manier. And with great respect, I submit that at this stage you maybe should give us some ruling again as to what the status of the evidence that this witness is now alluded to is, and whether it is admissible in any way. It clearly doesn't contribute to your proceedings. All that he tells you, definitely relating to my clients, is what the press in certain press statements said. I will, in further reference, when we come to it, indicate to you, but I've checked all the sources that he relies on, and it all emanates from press statements and press releases.
Dr. Hughes, before you respond, maybe let me point out to you that we have received correspondence from Weber Wenzel, where they told us that the report at Davis Oplinton, it's still under clients and attorneys' privilege. Their clients have not waived their rights to that document. In the light of that, do you want to respond to what the two advocates have said? Basically, what they are trying to say is that, by referring us to press statements without adding anything to that is not quite being helpful to the Commission, because, we don't know what value is being added by various press articles, because we are trying to make factual findings at this Commission. Do you want to respond to that before we proceed?
Chair, I of course accept your ruling. So I will divert my attention from the leaked report in question. But I will say that issues that will come up elsewhere, or Ferristal's relationship with Chippy Sheikh. The fact that the German Public Prosecutions Authority did an investigation into Ferristal is a fact. That Ferristal then commissioned an investigation to investigate why there were so many, not only allegations, but proven instances of bribes being paid, which in turn led on to this investigation, which, as I said, in respect for your ruling, I won't entertain further. But a number of these issues that are raised in this report will come up through other sources later on in my investigation.
Dr. do I understand you to be saying that the Germans haven't investigated? You say the Germans haven't investigated, or are you saying that they have investigated? Maybe I misunderstood it there.
Chair, there was an original investigation which is referred to at the bottom of page 66, where it says that this American law firm was hired to clean up Ferristal following a series of corruption scandals and the arrest of one of its board members by the German Public Prosecutions Authority last year. The German Public Prosecutions Authority produced a report. That's what I'm referring to, Chair.
Dr. Woods, as far as the report from this law firm we're acting for Ferristal, I think I have already made a ruling there. So that report at this stage is not admissible. And two, when you deal with the newspaper articles, bear in mind the question that I've asked, and which is, of what value is those newspaper articles going to be to us? I think if we can proceed, but then bear those two things in mind. Thank you.
Thank you, Dr. Woods. Maybe then let us proceed then on page 8. You were now dealing with the German investigation of Tyson. Without reference to the newspapers, based on your knowledge during, as chairman of Scopa or during the investigation, just to take through those topics without making reference to the allegations raised in the newspapers. I'm just saying that, are you able to assist the Commission with reference to the subtopics that you have mentioned under the Roman figure 1, 2, 3, and 4, without even making reference to the press statements?
This is starting on page. Yes. I'm still battling with. While I, of course, accept your earlier ruling, Chairperson, I'm just trying to make sure I understand the way it preempts my further evidence coming from press cuttings. I believe everything.
Dr. Owens, I'm not preempting any further evidence. If we do have evidence, we would like you to give us that evidence. We're just referring to you reading other people's reports, and we have told us that, those reports are still subject to client and attorney privilege. We are not stopping you from reading any evidence, and we are saying to you that as far as newspaper cuttings are concerned, just bear in mind that, we are a bit worried about the evidential value that must be placed on those articles, because those are purely newspaper articles. You are not the author of those articles. You cannot tell us that those articles are correct in all respects. Just saying that you must bear those two issues in mind when you testify. I'm not stopping you from giving us evidence. If you do have evidence, give us the evidence. Give us the evidence.
Thank you for giving me that clarity, Chair. a lot of my evidence will come from newspaper articles. As I indicated earlier, there will be carefully chosen articles which I believe offer substantive allegations by virtue of who wrote the articles, by virtue of the content of the articles, where they got their information from, the investigation they did. So it's not something I can just dismiss because it's a newspaper article. In a sense, it amounts to research. So it has substance, it has very often has credibility. And I also explain my approach of accumulating such evidence in order to show bigger pictures and patterns. And so we might not be of one mind here, where I believe these ultimately together add a lot of value and paint a fairly strong picture. As I go through them, it might not appear that way to anyone listening to what I'm saying. So I hope you'll give me that a bit of latitude, Chair, that I am trying to use methodologies which are well established in producing knowledge. I have a strong background as a social scientist, our job being to produce knowledge in a different way to what the legal fraternity do. So I might just need a bit of understanding from you as I go through.
Okay, we may proceed then.
Just hold on, Advocate Park. I don't quite follow what Dr. Woods is saying. At the end, he said that no, we should just give him a leeway. I didn't quite understand what he meant by that. Can you just explain again, Dr. Woods, if you don't mind?
Yes. Chair, I think it would be disruptive and if I was to be challenged on each newspaper article I quoted from, on the basis that it was just a newspaper article. So I'm trying to reason as to why these are not just newspaper articles. Why in the biggest scheme of my presentation, they offer, in many cases, a fairly compelling picture. So I'm just asking you for a little bit of grace in allowing me to present excerpts from the press articles which are amongst the items in my evidence bundle.
Okay, you may
Thank you, Chair.
I think we're dealing with Roman figure 3. You may proceed on page 8 of your statement.
Yes, fortunately, the client-attorney privilege only happens in one case, so I'm pleased that that shouldn't get in our way again. The German investigation of Thyssen I refer to, where the Office of the Public Prosecutor in Düsseldorf investigated the GFC and an alleged $25 million paid, in which it was said most of which flowed directly to South African officials and members of the cabinet. It's also said another $3 million was paid to former Chief of Arms Acquisition, Chippy Sheikh. Now, I have to be careful here because I would hate something to be coming into this investigation that, in fact, also existed in the investigation which you've ruled against. So I'd have to be guided there.
Dr. Woods, before we pass this paragraph, I'm quite interested. I see you make a very interesting thing is mentioned here, where it says that, most of which flowed directly to South African officials and members of the cabinet. I'm quite interested to know who is the member of the cabinet who benefited from this, who got part of this money. I'm sure it will really help us a great deal to deal with some of the difficulties that we have. If you can be in a position, if you do know, tell us exactly who the cabinet minister is who might have received this money, if you do know.
No, that's a very fair question, Chair. I'd like to pick up with the issue that was raised early on. I agree, and if I had been allowed to entertain the previous document, I would not for a moment have referred to that Sunday Times article. I have no knowledge of funds having flowed to the cabinet, especially to the president at the time or the deputy president. I do have some evidence regarding monies having flowed to the late Minister of Defence, Joe Modise, but not to other cabinet ministers. So even though that's what a report might quote, the issue I'm not trying to raise here, I'm just trying to raise, was there corruption? And if it says there were dubious amounts, substantial amounts paid by suppliers to parties in South Africa, that takes me as far as I want to go.
Dr. Woods, let me understand what you're trying to say. Am I correct to say that you are now saying you are not aware of any cabinet minister who has paid part of this money? Am I right to say that you are not aware of any?
Yes, Chair, but I am aware of benefits, whether it was through these monies or in other forms, that were paid to a cabinet minister at the time, the late Joe Modise. The rest of the cabinet, I say, I have no knowledge whatsoever of any of those, and in my personal opinion, I doubt that any of the other cabinet ministers would have taken money. I separate the case of the current president's case because that was very peripheral to the arms deal. It was very peripheral to the transactions that led to the supply of the arms. So in addressing your question, I believe the cabinet ministers, besides Joe Modise, and concerning commissions, bribes paid, I personally feel it's very unlikely, and I don't believe any of them did receive any money.
Now, let me be direct again. Concerning Mr. Joe Modise, what evidence is there that he received money? Now, tell you why I'm asking you this question. Because you are trying to look at various areas where we can possibly find a trace of that money. Can you be in a position to assist us any further, except just saying that Joe Modise received money?
Chair, I chose my words carefully, and I never said the late Joe Modise received money. I said benefits. And there we can talk about benefits, whether it's his shareholdings and a number of other issues which I do intend to touch on. But I would like to distinguish between suggesting that he took a bribe or received some other favors.
So do you understand that you were saying that you never said Mr. Joe Modise received any money as a bribe?
Correct.
Now you're saying that he received benefits.
That's right.
Are you in a position to give us full details of those benefits so that we can try and make a follow-up?
Certainly, Chair. Would you like me to move on in my presentation to where we start dealing with those issues?
You can do it the way that suits you, as long as at the end of the day, if you can, then you tell us about the benefits that Mr. Modise has received out of this transaction so that we can make a follow-up.
I'll do that, Chair. Thank you.
Thank you, Dr. Woods. You were dealing with paragraph 7 of your statement. Have you dealt with all the issues you wanted to deal with, paragraph 17?
Yes, I think it It was information which came about through an investigation by a credible source, the Office of the Public Prosecutor in Düsseldorf, and I'm simply making the point, which I'll be making over and over again, that dubious monies were paid by suppliers to parties involved with the South African arms deal. I don't need to go beyond that point here. I have a collection of background documents if you wanted to indulge detail, but that's not. I'm just trying to build a case that there was probably corruption, given all that we know.
Just asked about Annexure GGW9 on page 72. You refer to it as support for the averment that Shipi Sheikh was paid $3 million US dollars. Can I ask you, have you got it? Annexure 9 on page 72. It appears to me to be an email, a document. Who's the author of that email?
Yeah, Chair, there's Commissioner, I beg your pardon. There are a number of databases that have focused on the South African arms deal. IDASA had one, the Institute of Security Studies had one, I think Politic Web under Marburg has one. And and an individual, Richard Young, has one. Part of a free service which Richard Young offers whoever's interested is that any arms deal related press statements, in this case one by James Marburg of Politics Web, he will distribute to a distribution list he has, which is quite a considerable list, I believe. So the email comes via Richard Young, but that is irrelevant. What is relevant is that there's an article written by James Marburg, and who discusses the case, the investigation I referred to a moment ago.
So the author is James Mayberg.
Yes, Commissioner.
The document was sent to you by Mr. Richard Young.
That's correct.
Do we know something about who James Mayberg is? And in what capacity is he writing this?
I don't really, Chair. I believe that he's something of an expert, however one might define expert, on the arms industry, and has, amongst other military issues, seems to have some interest in the arms deal, and over the years has produced pieces from time to time concerning the arms deal, and then this would be one of those. But I'm afraid I can't offer you more than that.
Thank you.
Chairperson, our objection to this Annexure GG1 will follow that we raised with regard to GGW's 8, and for the same reasons too. There's lots of mention of President Mbeki here, and what he's alleged to have done or not done, but no real evidence, and I don't think we'll be seeing Mr. Mayberg before this commission.
Thank you, Chair. Chair, I think Mr. Moran has raised a very important point, but I thought that the probative value, in terms of evidentiary value of those press statements may be issues that the Commission may decide later on when it considers the totality of the evidence. At this stage, I don't see any prejudice because these publications have been in the public domain, and I guess for progress' sake, we may carefully refer to those press statements, but the Commission will have, at the end, be able to determine the evidentiary value thereof.
Mr. Chair, sorry, if I can respond to what has now been stated. With great respect, it is a rule of the law of evidence that if evidence is being presented to a body like yours in court, which has no value, evidential value, then it becomes irrelevant, and that makes it inadmissible. So it's not an issue where we can proceed and allow it and then subsequently make the decision. The problem that we have is that very serious allegations are made against various individuals and entities in these submissions based on absolutely no source and or personal knowledge from this witness. And on that basis, I would respectfully submit that the evidence that is being tendered based on these newspaper articles and or persons that this witness doesn't even know and cannot stand in for reliability, etc., should not be allowed. It's simply inadmissible, as you please.
Advocate Parra, just before you respond to what Advocate Celia has said, let's look at page 69. The email, apparently it comes from somebody else who then sent it to Dr. Young. Dr. Young would then send it to a list of a host of other people. And the original author of this document, we don't even seem to know who it is. Doesn't that demonstrate the point that Mr. Celia is making? This one, I mean, you know, Dr. Woods got it from Dr. Young. Dr. Young got it from so-and-so. So-and-so got it from so-and-so. And I'm not quite certain whether are we going to come to a point where the author of this document comes and testifies about the veracity of this document. Now, if that is the position, if it's on a newspaper article, a lot of people's names have been mentioned in there. And we're not certain whether the journalist will come and testify. What then becomes the value of that document? There's the first thing. Then the second thing is a question of relevance. I'm not quite sure how do you suggest that we should deal with it. You know, it's easy to say that, you know, you can look at the evidential value of the document at the end of the day. But in the meantime, people's names have been mentioned. In the meantime, people's names have been mentioned without any foundation, unless if it's all at the end of the day, they, you know, are given evidence which supports the basis on which that article is based.
Thank you, Chair. Chair, I was just making a submission on the basis just for us to be able to progress. But I get the points. I mean, the issues that are raised are points of law. And I'm saying this carefully because I'm not acting on behalf of Dr. Woods also. No.
Thank you, Chair. It is not so much a message as the Chair suggests. I was making a point to Advocate Zondi in response to a very limited issue the Chair had raised, and I think the basis on which Mr. Moerani's objection is based. And that is that these documents place out there names of people and make allegations. The correction I was seeking to make is, if they are newspaper articles, The allegations are out there. So it is not like through this witness or through this process, the allegation will be made. There are newspaper articles, they've been published, they've been highly circulated. It is really a reiteration of what is already out there. If there is to be a debate about the value thereof, I believe it must center around whether any reiteration is necessary in this commission, but not to suggest that for the first time the allegations are being made. I'm not leading Dr. Woods, I am not involved in his testimony, but I do not understand an objection that reference cannot be made to an article that has placed a name out there. To some extent, I agree with Advocate Mpacha that the commission will determine the evidentiary value thereof in the fullness of time. However, as a commission, I believe that the commission is entitled to take on board all sources of information, and the commission is at liberty to consider even evidence that at first blush would be inadmissible in a court of law. This commission is faced with a whole number of allegations made from different sources. The question for me is whether witnesses that appear before the commission can substantiate those allegations. The fact that the allegation was made in the newspaper is not the issue. The issue is whether or not that allegation can at any point be substantiated. So personally, I don't believe that there is any expose that can be made unfairly through reference to articles. The articles are out there. They've been published over the course of the years. They have been read. Maybe this witness must explain why it is necessary in delivering his testimony to make reference to those articles and where those articles assist him. But a complete ban on reference to articles is what I personally was struggling with, and that is what I was telling Advocate Zondi, Chair.
I understand what you're saying, but then I think I'm still making that point again. If it's all an article, people's names have been mentioned, there must be a reason why that person's name has been mentioned. Two, we must be satisfied that there will be evidence which will support the allegation which has been made in that newspaper article. Short of that, I think it will be unfair to say that because your name has been mentioned in the past, we can continue doing that. I don't think that will be fair to those witnesses. We must be very careful when we deal with newspaper articles, particularly with a document like this one that I've just referred Advocate Mpacha to, where there are about 4 or 5 people in the middle who prepared something which ultimately ended up on our desk. And we're not certain whether any of them is ever going to come and testify. So I think we can allow some limited reference to this document on condition that people's names are not brandished around, unless if at all there's going to be evidence to support that. I think this is what we're going to do now, unless if at all there are other people who feel uncomfortable about this ruling.
Mr. Chair, now, maybe just to indicate to you why we are concerned about the evidence in this regard. If I can refer you to page 87, for instance. That's another, it's Exhibit GGW12B. That's another email apparently emanating from Mr. Richard Young. And basically the gist of the allegations against my client, Mr. Shlongwane, is to be found in this email. If you look at a paragraph in the middle of the page, it starts off with a quote, "The consultant who received the secret payments is reportedly Fana Shlongwane." And then it's alleged that he received up to 200 million rand in commission relating to the acquisition of 26 Gripen fighter jets. That's clearly allegations of a very defamatory nature, accusing Mr. Shlongwane of corruption. But the interesting part, Mr. Chair, if you look just further, who's the source of this information? It's Mr. Meinier. Mr. Meinier already testified to you that he has no knowledge of this. He doesn't stand in for the truthfulness of these allegations. He doesn't stand in for the reliability and or correctness of any of the newspaper articles and or documents that he relies on. But what we have now is a repetition of that by this witness relying on Mr. Meinier. And with great respect, that leads to some extent to an absurdity. The repetition of inadmissible evidence doesn't make it relevant and or admissible.
I'm sorry for getting silly. Where does it appear that Dr. Young got this information from Mr. Meinier?
Mr. Chair, if you turn to page 9 of his submissions, paragraph 20 is basically the gist of the very serious allegations against Mr. Shlongwane. Paragraph 20 on page 9. And then as his source that he relies on, he refers to GGW12A, which is a newspaper article, and GGW12B, which is this email. If you look at 12A, then it doesn't assist much in this regard, but 12B forms the very basis of this serious defamatory allegation against Mr. Shlongwane. And if you look what the source of this witness is, then it's Mr. Meinier, who already said he doesn't know of it, he has no knowledge of it, and he doesn't stand in for the correctness and or the truthfulness of this. And in the process, Mr. Shlongwane is being defamed in public based on this, with great respect, baseless sources quoted by this witness, as you please.
Advocate Park, do you want to respond to this one?
No, Chair, I agree. We have not necessarily, at this stage, come to that part that Mr. Lewis is referring to. And to avoid that, I think Mr. Woods would have to be able to give evidence without necessarily referring to those press statements in order to be able to avoid, as Mr. Lewis says, some defamation. But what is important, Chair, is that this is a commission of inquiry, not necessarily a court of law, and it's an investigation to inquire into. And I understand the concerns that are raised at this stage. And what I want to repeat is that these are newspaper articles that have been in the public domain. And I think that the very fact that Mr. Woods is referring to these articles does not make them new allegations. And it is for the commission to determine, after we would have given evidence, whether they'll place any value in his interpretation of the press statements.
Let's look at the question of relevance. Mr. Celia says that Dr. Woods relies on a particular document, and the author of this document relies on Mr. Meinier as the source of the information. And Mr. Meinier, we know that he was a certain know nothing. Now, where does that put this document? Are we going to go through documents which clearly will not help us in any way, which are totally irrelevant, simply because it's a newspaper article which has been attached? I think what we are going to do, and I think maybe in order to have progress, you can make reference to those documents, but then just be careful. Just keep in mind what we have said, particularly those that it is clear that there cannot be any, that is not likely to give us evidence which is going to support the allegations contained in those articles. Okay? I mean, maybe let's proceed on that basis.
Thank you. Dr. Woods, do you want to make any comments to the debate, or you are happy to proceed?
So I do, Chair. Firstly, I take exception to Advocate Salia's.
Dr. Wood, if you don't mind, can you speak directly into the mic? We're struggling to hear you.
Perhaps the technical people could turn the volume up a little. Chairperson, I take exception to Advocate Salier's suggesting that what I'm presenting is not evidence and it doesn't add value. It's a subjective comment. He doesn't know where I'm going with this. I don't know what his motive is, but I have explained on at least 2 occasions this morning that I'm building a case, and across all these documents I refer to, press statements and others, that a picture will emerge which I will support.
Dr. Wood, let me help you. Advocate Salier is representing Mr. Hlongwane's interest on instructions of a firm of attorneys. Now, I think that is his motive. I don't think he's got any other motive except that one. He's an advocate representing a client's interest on instructions of a firm of attorneys.
So, okay, I concede that it's his right to be disruptive. Secondly, Chair, my evidence is contained in my statement. In each paragraph of my statement, I raise an issue. To show that I haven't just sucked this issue out of the air, I supply some documents, which is often comes from my press article. As I've said repeatedly, I've chosen my press articles carefully. And am I expected to take a press article and cut one single paragraph out of it which relates to my press statement? I thought I was going to have the opportunity, as my witness leader here is guiding me, my evidence leader, to show you which paragraph on the press statement. If some people want to entertain all sorts of other obscure and irrelevant paragraphs and make an issue of it to try and discredit my evidence, and to have you rule that I cannot produce this evidence, then I'm not sure where we're going here.
Thank you, Dr. Woods. Maybe let's proceed then, and where necessary, if we can avoid making reference to press statements, let's do so. I think we're done with paragraph 17. We were now going to proceed to paragraph 18 in relation to the SFO investigation into the BAE.
Just on paragraph 17 and on GGW9. Correct me if I'm wrong, but as far as I could see, this information relates to the Office of the Public Prosecutor of Düsseldorf, Germany. It does not relate to the subsequent investigation, the one which you have instructed me not to quote from. So I believe I have the right to quote from this document. But I just want to be assured that
Are you referring to the newspaper cutting on page 72, Dr. Woods?
yes.
What particular reference do you want to quote? Maybe you can just refer the Commission to the specific paragraph.
Well, they refer here to the German investigators. You know, they claimed in a letter for assistance to Swiss authorities last year that the consortium had paid considerable bribes to achieve the conclusion of the agreement. They refer to the amount of the bribes and the kickbacks, who they were from, and to the letterbox company in Liberia to whom it was paid. It mentions in that investigation $3 million, the investigators allege, had been paid to the former chief of arms acquisition, Chippy Sheikh, through another letterbox company. It mentions the name. It also mentions that the primary focus of this article will be on the ship platform equipment. And it goes on to bring up the issue of Bazan, who I will later argue unfairly lost the deal to. Thank you.
Thank you, Doctor. Then let's proceed into paragraph 18, the SFO investigation into BAE. Can you just take us through that paragraphs?
Yeah, documents relating to this investigation showed that showed US bank statements relevant to BAE that paid over £15 million to advisors in order to assist in securing and maintaining the South African Hawk and Gripen contracts. It says between September 2003 and January 2007, Hlongwane Consulting was paid in excess of £10 million by BAE. The SFO investigation revealed that Hlongwane also received 51 million South African rands in an agreement with the South African registered entity. In relation to this, on the 9th of June 2003, the British Trade Minister, Patricia Hewitt, confirmed to the House of Commons, so this evidence will be in the British Hansard, that BAE Systems had paid a commission on its contract to supply Hawks to South Africa. Thank you.
Thanks, then. Let's proceed to the Accountancy and Actual Discipline Board investigation into BAE. That is page 9, paragraph 19 of your statement. Can you take us through that paragraph?
Chairperson, to the best of my knowledge, this investigation is ongoing, even though it was announced a couple of years back, and I've watched the media carefully, as have others. We haven't seen the outcome of it, but we know for a fact there is this investigation. It's an investigation that doesn't ask whether commissions were paid. It was asked the channels through which they were paid. And particularly, it's been asked to investigate the audit company KPMG as to how they organized the payments of these. So even though we don't know the outcome as to how these commissions were paid, it would seem that very powerful, very reputable bodies seem to agree they were paid. And let's hope that we get the findings from this investigation in the not-too-distant future, so it can add to the type of evidence which I am offering to you today.
Thank you, Dr. Woods. Then I think paragraph 20 is the paragraph that Mr. Cilliers was concerned about. It relates to the sub-investigation into the Gripens. And maybe let's now go to paragraph 21 and 22 in that regard, if you can take us through those paragraphs 21 and 22.
Can I get assistance from you, Advocate Lebala? This annexure GGW10, it's supposed to be on page 78. I can't find this page 78 on this document.
Commissioner Musi, page 78. I think it might have misplaced the document. We'll provide it for you.
Advocate Parr.
Thank you, Chair. May you then proceed? We are on paragraph 18. Oh, sorry, paragraph 20. My apologies.
May I just refer back to Annex 10, TGW 10, and paragraph 18 regarding the BAE deal. The source here is the Mail and Guardian, by the country's, I think, generally two leading investigative journalists who have a very impressive track record in producing responsible evidence. They talk about documents they have in their possession, documents which were used by the Scorpions to motivate a particular raid. So I'm arguing I have a press article, but I'm saying please accept it has some credibility. What it says, it shows, once again, it talks about the commissions paid to agents by the British defence giant and the huge amounts concerned, which is part of a theme which I've been presenting to you. The paragraph that follows is interesting, and I will refer back to this later. They also argue that BAE could not produce evidence of legitimate services by the agents which could justify the huge amounts paid to them. So people receiving these so-called commissions, British Aerospace are unable to say what they did for that money. I think it's an important point to note, as I'll later explain. The documents, which are affidavits by South African and British investigators, they are financial statements and correspondence, form the basis of the documents to which I'm referring. And they not only disclose the vast majority of BAE's commission payments, they also how the covert payments were made in a series of undisclosed to agents. Once again, if it was purely commissions, then it would appear in their books as commissions, and there would be nothing to hide. But that's not what happened here. Also, how BAE allegedly tried to hide the extent and the timing of their relationship with Hlongwane from investigators. Details of interventions by Modise and then defense procurement boss Chippy Shake, which also advantaged the BAE deal. That theme of Chippy Shake, which will be there to haunt us.
May you now proceed to take us through the ASAP investigation into the Gripens?
It's now, there was an objection early on to the use of 12B. So I'll only refer to 12A, but it says the same thing. And it says nothing about Richard Young or David Mania. It says what SAB's own investigation of themselves says, where they admit to guilt, they admit to bribes being paid. I think that's pretty hard evidence, Chairperson. Sorry, not on the international investigations. I'm up to paragraph 23.
I was just mentioning that, are you satisfied with your explanation, what you said in respect of the sub-investigation to the Gripens? Is it your contribution? Is it a contribution in respect of paragraph 2222 under the subheading sub-investigation?
By international investigation. Yes, that's the conclusion. But in summary, I'd like to make the observations that these were investigations made by organizations, by sometimes state organizations, sometimes other investigations, which by all accounts were independent and free from outside influence, and that each of these investigations have, amongst their wider findings, revealed dubious payments to have been paid to South African politicians, public officials, arms deal-related businessmen, and other middlemen. That's the constant theme.
Thank you, Dr. Woods. Then let's turn to page 10 of your statement. I think you then discuss the topic titled, Why Commissions Are Likely to be Bribes. Can you take us then through paragraph 23 and 24?
Yeah, I was informed that when former President Mbeki appeared before this commission, he suggested there was nothing wrong with arms suppliers paying large commissions to whoever they choose, and that's the nature of the business world. And no doubt there are others that hold that view as well. And no doubt the recipients of those commissions will also try and legitimize them. But I want to point out again, and most of the exposés in the arms industry as to where corruption has taken place has concerned bribes or commissions that were in fact bribes. So the word commission in the arms industry is most often just another word for bribe or kickback. So once again, President Mbeki didn't appear aware of that and how things have transpired in the arms industry and as they are recorded. But more importantly, if we look at the nature of how the South African arms deal was
It appears that the witness is referring to the evidence of President Mbeki without actually having read it, because President Mbeki never spoke of large commissions. One will search in vain in the records to find any reference to large commissions. And in any event, his evidence did explain the difference between a bribe and a commission. I think if the witness has to refer to evidence given by any other witness, I think it's important that he must have read that. Otherwise, the impression that's going to be given here is that he's quoting correctly from the relevant evidence.
I take their point, Chair. The word large shouldn't have been there, then I apologize for it being there. Secondly, the way the arms deal was constructed as a government-to-government deal, ultimately it was left with no scope for middlemen and no need for consultants, especially those who might otherwise be deserving of such large commissions and success fees. The official position of government is that the transactions were negotiated directly by the South African government and the suppliers. So in my opinion, there was no other role for anyone else to pay. And I refer back to a document I referred to a moment ago, that in the BAE deal, BAE said exactly the same thing, that they have no records of not very good at finding my documents, but I did spell it out before that BAE themselves say they never paid any, there were no such services offered that deserved such payments. Words to that effect. I can find the exact quote once again if you would like me to. So I'm
Great respect, I would invite this witness to bring the source from within BAE where they stated that there was no services rendered for the commissions paid. It simply doesn't exist.
Are you in a position to respond, Dr. Woods?
and it's perhaps not a relevant statement, but I'm sure that BAE would have sued the Mail and Guardian and demanded those documents if they were just making it up, as is suggested.
Dr. Woods, just listen to the question very carefully. Is there any evidence that you have which is going to back up that statement, that BAE agreed that no services were rendered?
So I referred in some detail to the evidence as is, and the documentation and the source as was quoted in the article. If you believe that's insufficient, I'm at the mercy of your judgment call.
Okay, let's proceed. I can assume that there doesn't seem to be any basis for that statement that BAE agreed that work was done and they paid large sums without any services being rendered. Can I assume that that is the position, Dr. Woods? Except, of course, referring to that Mail and Guardian article, if it truly does say so.
Chair, I would obviously prefer you not to assume so, but I think reading the article carefully, who wrote the article, where they say the evidence comes from, and that from that evidence, the argument that BAE could not produce evidence of legitimate services by the agents which could justify the large amounts paid to them. I think it would be wrong to simply discard that and throw it away.
No, apparently you don't understand me. I'm saying that, that statement does not say that BAE admitted that they paid large sums of amounts of money without any service being rendered to them.
Well, if the investigators who spoke to BAE says that BAE could not produce evidence, I would think by deduction BAE are admitting that they don't have evidence to show that there was reason for these payments being made.
Mr. Chair, if I can refer you to GGW 10, in fact, the same investigative journalist stated the contrary. On page 79, second paragraph, he in fact stated, BAE has consistently maintained it acted legally. That's a far cry from suggesting that BAE admitted to the Mail and Guardian or to Mr. Bremer that they paid large sums of commission without any services rendered. That has an innuendo of corruption. Here they clearly maintain that they consistently acted legally.
Dr. Woods, do you want to respond to that?
So if I had 5 minutes, I would wish to respond to it, but because I need to just get the context here, whether the gentleman is not interfacing two issues that don't belong together. to take one paragraph from page one and another from another page and to say they contradict, I think it requires one needs to apply one's mind a little more responsibly before making the deduction that he made.
So you need some time to read the Mail and Guardian article so that you can be in a position to respond to what Advocate Celia said.
Only if you would like me to respond, Chair. Because only if you would wish me to respond to the gentleman's point. I've already made my point in terms of my statement.
Now that I understand, but then my difficulty is this statement that he has referred to on this article. Because whatever you have said, then you have based it on this article. But then there is a paragraph there which says that BAE has consistently maintained it acted legally. And that seems to contradict what you said earlier on.
Yeah, I would ask, in what respect does the article say BAE has consistently maintained it acted legally? Maybe the gentleman could make up something from us there.
I'm not quite certain whether I'm going to allow that for you to ask Advocate to answer your questions. You are the one who relies on this statement. You are the one who put in this document in the bundle. And you are making statements arising out of this report. Probably you are the one who should explain to us, what does this mean? This is a document that we're relying on.
Chairperson, the statement raised was BAE had consistently maintained it acted legally. Acted legally in what regard? It doesn't say there that it acted legally in paying Hlongwana commissions. If it said that, then yes, there would be a contradiction in what I said early on from the earlier paragraph. It doesn't say that.
Okay, it doesn't help us much. Advocate Kalmpawo, let's continue. That doesn't help. That answer doesn't help us in any way.
Thank you very much, Chair. Maybe let's conclude then this topic by looking at paragraph 25, page 11. I think it concludes the topic that we were discussing. Can you maybe take us through that?
I express the views here, Chairperson, that surely there is enough that arises from these international inquiries to suggest that big monies were paid. And if you accept my arguments on the commissions versus bribes issue, why there was any need for big monies to be paid to individuals, both inside and outside the process. So the first question is, why did this happen? But I do conclude by saying, to me it's incomprehensible as to why the South African government declined to contemplate the foreign investigation findings referred to it. I know the head of the Hawks claimed to have written letters to a couple of these investigators and claimed to have not received a response. But the arguments that came from SFO, for one, and the public prosecutor from Düsseldorf, two, I think there was a third as well, claimed that they had been unable to get the cooperation of the South African government. So I'm assuming the latter to be more plausible, and that for me it remains incomprehensible that the South African government didn't say, thank you for the good work you did, how can we cooperate? Let's together get to the truth of these issues. They did not.
Thank you, Chair. I see it's 1 o'clock and we are starting a new topic altogether.
Let's take a lunch adjournment until 1:45. Thank you.